shortly. I've just got a few minutes, and I just wanted to do this. So I've titled this Lachlan Murdoch versus Crikey. We know that Lachlan Murdoch is suing Crikey over an article that they wrote about him. It has allegedly destroyed his reputation. So I thought we'd have an update on that, because there is some developments on that. And it's really, what's really interesting is that the media has been very reluctant to talk about it. I wonder why. So we've had all of this stuff happen. So you can see that it started in, 24th of August. So at the moment, there's 2 interlocutory applications. So what happened was, there was an application, and then there was a hearing, and they essentially, Crikey had to amend the defence, because that was what was stated, and then there's been an amended reply. Now, what's happened in the meantime is that on the 7th of, assisted dispute resolution filed by Murdoch on the 7th of December. So they actually went to mediation. They had to attend mediation on the 21st of December at 9:30, and it was not it was not resolved. I'm not surprised. So mediation was not resolved. They couldn't come to a consensus. So when we look at all of the stuff that's happened, there has been so much that's happened. There was the first case management. So 22nd of December, there was a case management hearing. There were some orders. On the 30th of January, which is coming up, in front of Justice Whitney, is an interlocutory hearing, which will hear the interlocutory applications that were filed here. We're going to have a look. And then the hearing is scheduled for the 27th of March. It's going to go, so it's got its court dates assigned. So let's just have a look and see what this is. This is an interlocutory. This one I think was the one where they filed the amended. I think this was the, yes. So this was, so has there been another interlocutory application made? Let's have a look. Yes, on the 21st of December, there was an interlocutory application made, and then there was affidavits, and then submissions, and an affidavit. So this is all the filed paperwork so far. Look at this. Amendment, notice address, defence, reply, affidavit, interlocutory application, outline submissions, interlocutory application, submissions, affidavit, submissions, outline. Then there's a reply. A whole pile of affidavits here, look. Ooh, and I'm wondering whether they're, yeah, and then notice of constitutional matter, affidavit of service, submissions, affidavit, interlocutory application. There was one filed there. 19th, an affidavit. Another interlocutory application was filed on the 21st of December. I don't think we've got those. So the one that we've got here is the 23rd of December. Here, they haven't uploaded those yet. Alright, what's this one? That's also the, yeah, alright. Because they wanted stuff struck out and everything, so that's what happened. So let's have a look at the orders from this case management hearing. And then we'll look at the amended defence and reply. It's, yeah, there's a lot of money being spent at the moment. So on the 22nd of December, Justice Whitney, on or before the 30th of January 2023, the respondents filed and 7 affidavit in reply. On or before the 4 p.m. the 20th of January 2023, the applicant filed and served submissions not exceeding 5 pages. So let's have a look. We'll go back and see what's been filed in a minute. On or before the 4th of January 27th, the respondents filed and served submissions not exceeding 5 pages. The application is listed for an interlocutory hearing on the 30th of January 2023 at 10:15 a.m. So that's just orders. And then they've got here that there's an interim confidentiality order as well. So pursuant until further order, the information contained in the first respondent's answers to interrogatories 58 and 59 not be disclosed to any person other than the respondents and their parties' legal representatives. So there's been a confidential order placed in there as well. So that's going to be heard then. So let's go back here. So we've got, yeah, we've not got the new stuff. So we've not had the stuff that's been filed most recently, which is fine. But as I said, they went to court. They didn't meet the requirements. So as I said, the documents filed. So let's look at the documents filed. So we've had submissions have been filed. So the other side have got until the 13th affidavit there. So that was done. 20th of January. So they've got the 27th is when the response has to be done. Okay. So let's look at the amended defence here. There's 14 pages here. So now what they do when they amend a document, they actually have to keep the original. So when it's amended, we're just going to have a very quick look through this. So let's have a look. This is the amended defence. So what they actually have to do, they have to cross out the problems that there are, and then they put under, and then they have to highlight the section. So Mr. Trump alleged that it was stolen by reason of widespread voter fraud. They had to amend without any reasonable basis. They had to add that Fox Corporation and News Corporation are each companies operating global media conglomerates controlled or primarily controlled by members of the Murdoch family, being the family of which Rupert Murdoch is the patriarch. Again, they had to delete the words without reasonable basis here about allegations. And this would have been argued, this is what they would have argued in court about what they needed to amend, what needed to come out, and His Honour would have said, yep, this needs to come out, this needs to stay, this, you know. And it looks like, oh, there we go, was aware of facts, matters and circumstances set out in paragraphs 1 to 16. So they added a 16, I think. So we went through the original. So as I said, this is just the amended, and you can have a look. So this is how you do it. You know, they have gone through each paragraph, admit to paragraph, and so you've got to look at the, on the 27th of July, they made an offer of amends. They rely on the offer of amends. So you make an offer of amends, which is a part of the defamation thing. Again, there has been more changes here. The bad reputation of Lachlan Murdoch amongst the surrounding people in the sector of his reputation, co-chair of News Corporation, executive chairman and CEO of Fox Corporation, a global media conglomerate which published into our Fox News. So they've taken out some of this. You can see what's been taken out there. Just an interrogatories, and if the matter complained of is found to be defamatory in that it conveyed one which is denied, the respondents say the article concerned the matters of public interest set out, namely. So they're essentially using the public interest defence, which is a brand new defence now available. And more broadly, the influence on the electors and representatives. Yep. So again, they've taken this. Now, one of the things that they have defended is that it's related to government and political matters that affect the people of Australia. So that's why they're saying it's a public interest defence, and that they responded. So their defence is that it was a matter that was related to the Australian people. It affected the Australian people. Therefore, it is a public interest defence. Was it in the public interest to report it? That they've acted responsibly in publishing the matter, and it's called the Lange defence, so which is qualified privilege, which is known, or Lange. Some say Lange. I think if it was Langy, it would have a, anyway, Langy. Okay, in the alternative, they say, so what they've done is they've said, okay, this is our defence. However, in the alternative, the concept of reasonableness must be adapted, or the requirement more strictly construed, so as to ensure that an inappropriate burden is not imposed on the implied freedom. The imposition of the reasonableness criterion as part of the Lange defence is inappropriate and should be revisited. So they've gone, this is our defence. However, in the alternative, okay, so then we've got that, and it was amended on the 1st of November. Okay, so then Michael Hodge, King's Counsel, so in their reply, again, it's going to be very much the same, and okay, going to see if there's any changes in here. So they're saying in the Lang defence, Murdoch says that in publishing the article, private media Keane and Frey were actuated by malice in that they predominantly acted with the improper purpose or purposes of harming Murdoch and seeking to attract unwanted attention to the article by using Murdoch's name in the evidence, as evidenced in following. So they're saying that they didn't adhere to journalistic standards. And here's all the reasons why. That they're a member of the Australian Press Council. Public interest journalism, what that means. Reposting the article. Circumstances of the publication. So now they're going into the reasons why the said article I don't know what's changed from their original defence, whether there was anything. So they're saying by talking about the conspiracy and that because it was the parent company that Murdoch oversees, or the media company that Murdoch oversees. It's quite a messy one because I can't see many of the changes in there, but he is. It's interesting, alleging that on the 24th in an article written by Michael Bradbury published on the Crikey website entitled Australian Defamation Laws in favour of the reputations of the rich and powerful. Why? That Murdoch and other public figures who commenced defamation proceedings in Australia could not have done so in the US because of the requirement of malice. Now, interestingly, guess who the lawyer for the private media is? The said Michael Bradley. So he's one of the legal minds of Crikey. So and then they've alleged on the 6th of September, Crikey type 1G billionaires slap journalists because they can. That Murdoch's claim is an abusive process, and that other proceedings which his senior counsel was present. And again, that says the 8th of November. I can't see. I mean, I can't tell you whether that was a complete change of defence. They haven't. I'm not sure. I mean, I'm not going to sit here and read the 16 pages because, as I said, it was an amended. The defence was amended. I don't know whether this was a reply or an amended. Looks like they may have done a new one. But yeah, reply to amended defence. So they've just, it's like they've done a whole new one. So yeah, so in answer to paragraph the defence notice that had been deleted, meaningless. It's a standard, reply. Admits the article concerned an issue or issues of public interest. And that was actually argued when they went and argued there was a whole argument over whether it contained public interest. So after being told by His Honour that it does contain an interest of public matter, he can't now turn around and say it's not public interest, because His Honour's already ruled on that and said, well, yes, it is public interest. What it's going to come down to is if this untested public interest defence, whether whether the privilege or in the public interest, in the interest of the people of Australia, or whether the US political matters are actually of interest of Australia. So they're trying to show malice. They want malice. Alright, well, I'm going to leave it there because my neighbours just got excited again. I'll see you later. Bye.